We are live.
All right. Good evening. This is the House Judiciary Committee. We're having the first part of our voting session tonight on the Speaker's Bill, House Bill 670. We are going to tonight. There are a few amendments that have been offered. I thought what would make sense is to go through section by section, not individual sections, but sort of broad topic by broad topic in the bill. And we're going to have some just broader discussions about those areas. We do have counsel available if people have a legal or want maybe a little more specifics, but also obviously the vice chair, the subcommittee chair, who has been working so hard on this as well, can answer some of those questions too. So with that, the staff, Dylan, has sent out to everybody the bill as it stands, leaving subcommittee. It's 50 pages long. There are parts of it that were knocked out by the subcommittee, so it's not quite 50 pages, but let's go ahead and get started. And we're going to get started. We're going to get started on page 8 and 9 and 10. This is the section of the bill, and we're going to have this throughout the evening. Might be a little challenging for people at home, but we will do the best we can to let people know where we are in the bill. This is the section on the requirements related to no-knock warrants and the section related to warrants generally. I don't know whether people have any amendments they want to talk about conceptually in this area, but we could do that first. Or if people have questions about this section, you can go ahead and fire away. And I need to turn on this so that I can see when people raise their hand. Delegate Cardin.
Thank you, Mr. Chair. And just first of all, I do have an amendment which I think was given out by Dylan. Most of the amendment, in fact, about 90% of it was accepted by the subcommittee. Thank you very much, Delegate Atterbury and subcommittee for that. The one piece, which is on the second page of my amendment, part C, I think it is, just requires there to be a notice in bold print on the first page of the warrant application so that a judge sees it, that this is for a no-knock warrant. Mr. Chair, you indicated to me privately that you thought that was already sort of taken care of in the bill. Maybe you can explain why that is, and I won't press the amendment if everybody thinks that it's appropriately taken care of. I will say that State's Attorney Schellenberger, my state's attorney, indicated that if they do this in Baltimore County, it really does weed out judges who just don't adequately look at the warrant to realize they're issuing a no-knock warrant.
And I'll certainly defer to the vice chair consistently through our conversation here tonight. But my argument here is that under the bill as passed by the subcommittee, if you had a no-knock warrant, you need to ask for more. It has a higher standard under this bill than just an ordinary warrant. And if the committee looks at page, you don't need to change, Dylan. Actually, for the people at home, I think Delegate Cardin did a good job talking about how it's different. If we could go back to the bill on page 9, and I will give you a little bit of a chance to get there.
Mr. Chair, if you could just tell me, so there's 2 page numbers.
Right. So here's what you need to do. Dylan, point to the page 9 at the right there at the top. Well, that's not helpful. Right there where he's highlighted right in the middle at the top of the page. It's also at the bottom of the page. So for the purposes of the discussion tonight, you can ignore page, what this one I think is 6 of 24. You're looking just for the little 9, the little 10. You can see that on the next page there, because that's the best way that we can do it. So everybody got that? All right. So the reason that I don't think it's necessary, and again, we're just speaking conceptually here, I don't think it's necessary because of the additional requirements that are required under the bill that the subcommittee moved out for a no-knock warrant, it not only has to be a description of the clear and convincing evidence in support of the application, there has to be an explanation of the investigative activities. People can read this on their own, but I'm basically talking about the items under number 2 there from A to F. And for those reasons, I think it's clear already that this is a application for a warrant that is distinct from just an ordinary search warrant.
And I understand that, and I just wanted to put that out in front because it was pretty clear that the state's attorneys were saying that they want to make sure that judges know this. So as long as you think that because of the qualifications and the demonstration of clear and convincing, that a judge is not going to just go through it and say, okay, yeah, sign. They say, oh my gosh, this is a no-knock warrant. I really actually need to pay attention. As long as you think that's the case, I'm good, and I don't need to press my amendment.
Well, and again, we're not going to be voting one way or the other on the amendment tonight anyway. All I'm saying is, if I think that the backstop here is a little bit on the back end. If they execute a no-knock warrant and they didn't include that information, that's one problem they're going to have. The other problem there, the other thing again is the judge is going to see these enhanced requirements, and that's going to be what the judge needs as well. But Deborah Davis has her hand up. Delegate Deborah Davis, please. Uh-oh, unmute.
I just got 2 monitors and I'm having trouble. Okay, so in that same section, under number 2, I believe it's just an error, but we got rid of no knocks, right? And then we allowed them back under certain circumstances. And one of the circumstances in number 2 was the life and safety of the executing officer or another person may be endangered. I believe we want to say in danger.
Let me do one thing. So first, I wanted to address Delegate Cardin's conceptual amendment. I think.
I'm sorry.
No, you're totally fine. Totally fine, Delegate Deborah Davis. I don't mean, I got that. On the rest of it, I'll be looking here to the Vice Chair a little bit to take a look at that portion that Delegate Davis just raised. Let me ask, Delegate McComas raised her hand as well. Delegate McComas, is this regarding Delegate Cardin's conceptual amendment or something else more broad?
No, Mr. Chair. Okay, I'm going to kind of use apples and oranges, but it seems to me like with the FISA warrants, and all that hoo-ha, with the investigation of Trump and everything, I think it would probably be a good idea, because usually what happens is when systems change, I think it would be good to have that notice on there, just because that the judge, because they could be coming in the middle of the night to the judge's house, guys half asleep, you don't know what the circumstances are to get it. Now, I guess I think it's a good idea, because we're changing the rules of the road. And I think anything that, because everybody will know that things have changed. And I think it's a good idea to put that warning on there. It's just, all it is a little extra ink.
All right, I appreciate that. Let's now go to the larger issue of no-knock warrants. And Delegate Deborah Davis, would you please state again where you think that there is a typo?
I hope it's a typo. Under section 2, it says the life and we got rid of no-knock warrants except for the life and safety of the executing officer or another person may be endangered.
What page are you on right this?
Same page, same.
Oh, no, I see you. Okay, got it. Okay.
Yeah, may be endangered. And anytime you execute a warrant or definitely a no-knock, your officer's safety is endangered. And that is the whole reason why they did the no-knock. That's why they had no-knocks. So I believe we completely, if we use endangered, then we are getting rid of the provision that we're trying to have. I believe it's simply fixed with the life of someone else or an officer is in danger.
Mr. Chair,
The Vice Chair,
thank you.
I see what you're talking about.
Yeah, I think I would agree. I'm just looking up the definition of endangered, and it means extinction. I think endanger would probably be better terminology. I don't know if we want council to weigh in, but I see Delegate Deborah Davis's point.
Are we page 9?
We're on page 9. This is part of the bill that is existing law. The change in the law is there's a bracket after authorization down to number 2. So the
No, number 6, line 6.
yes. So
Thank
between actually lines 2 and line 5, actually. The policy change here is that it's taking out that you can request a no-knock warrant because somebody is getting rid of property that may be destroyed or disposed or hidden. But having said that, that's not Delegate Davis's point. She's talking about the maybe extinct and endangered part. So with that, we'll make a note of that. And I'd like to move on unless people have another question. I see Delegate Cox now with another question about the no-knock warrant section.
Thank you, Mr. Chair. And just real quickly, where it says or exigent circumstances for executing it prior to 8 a.m., I would like to ask whether or not the subcommittee would be, or the committee would be agreeable to adding in the terminology that's elsewhere in the bill that says clear or clear and convincing evidence exists that contraband could be destroyed.
Mr. Chair.
Vice Chair.
Thank you, Mr. Chair. So the work group and the subcommittee looked at the issue of property and contraband and was pretty clear that the whole point was to remove property because anyone can allege a destruction of property or contraband as a reason. And so the work group and the public safety subcommittee was pretty clear that they wanted to remove that element from the no-knock warrant requirements.
All right. Are there further comments on the no-knock section? All right. Delegate Grammer and then McComas.
Yeah, I just wanted to ask in general, aside from the time requirement, why did we decide out of all the options we could have selected to keep no-knock warrants? I think there's been a good argument made that frankly, that just makes situations more dangerous. And in the conversation we've had already, we're talking about judges not looking at the warrants. So can someone comment on that for me?
I'm not sure what the question is, Mr. Chair. Why are we keeping no-knock warrants?
Yes,
Question? Why we should keep no-knock warrants?
yes.
Because officers might think there is a situation where no-knock warrants are necessary and they need them. So we decided to increase the standard and the requirements for officers to obtaining a no-knock warrant. I mean,
I think it does.
Go ahead.
No, I'm sorry. I shouldn't please keep going.
I was just going to say there are going to be circumstances where no-knock warrants are warranted, but we wanted to make sure that the parameters for obtaining a no-knock warrant were tightened a bit. But there are certainly circumstances where they're still going to be warranted.
I appreciate that. I just think, and I appreciate tightening up the language and the process overall. I just see some of the cases we've looked at in the past, and this probably won't change much.
Delegate McComas, then Anderson, then back to Davis.
This is just, thank you, Mr. Chair. This is just a procedural question. Are we bound by what a work group and a subcommittee decides if the committee as a whole decides to go in a different direction?
I mean, again, if we're going to be considering amendments tomorrow night. So if you want to propose an amendment that would go in a different direction, you need to get something drafted and have it ready for 2 o'clock tomorrow.
Okay,
That's
so
part
we're
of the
not,
reason why.
so we're not bound by it. It's just, it's a procedural question.
Well, I mean, that's fine as a procedural question. You're not bound by it, but I will say that the vice chair, and it's the opinion of the chair, that the vice chair and the Public Safety Committee and the work group prior to that has spent the better part of 9 months kind of crafting this and honing this down. So I would say, at least in my feeling is they've put in a lot of work. So there needs to be pretty compelling, I think, reason to do that. But having said that, addressing that, Delegate Anderson is next.
Yeah, thank you, Mr. Chair. Somewhat addressing what Delegate Grammer asked and Vice Chair's response. About 15, 16 years ago, the legislature passed the initial no-knock warrant bill. And it was basically because when judges allowed or authorized warrants to police officers, they would go and serve the warrant. Some cases, the police officers would wait till the person answered the door. In other cases, if they saw someone looking out the window, or if they felt that there was some kind of weaponry inside, the officers would kick the door in without knocking. And the term came up where they didn't knock in the trials. And at the trials, to suppress the evidence, the judge would rule whether or not the officers acted properly. And that one of the things that the judges would rule is that if there were exigent circumstances, like if the officer's life was in danger, or if property was going to be flushed down the toilet, evidence would be flushed down the toilet, then the warrants were justified and the officer's actions after obtaining the warrants were justified. But the legislature didn't agree that the officer should be the one to make the decision after getting the warrant. So we put in specifics with regard to when a quote unquote no-knock warrant could be issued. And the two circumstances were what you've seen on your screens this evening. And that is one, whether or not property could be destroyed or secreted. And the second one, whether or not the officer's safety was at risk. What the work group did was to take out the first one because we felt the most important thing was the officer's safety at risk. My concern is that later on in the bill, when we talk about, excuse my voice, I'm sorry. When we talk about the time when an officer can when a warrant can be actually issued, and it's in number 7, a warrant to search a residence shall be executed between 8 a.m. 7 p.m. and then sub 4, Roman numeral 4, unless executing a no-knock warrant, which means what we already talked about, a police officer shall allow a minimum of 30 seconds for the occupants of the residence to respond and open the door before the police officer attempts to enter the residence, absent exigent circumstances. So basically what we're saying that, okay, he's got a warrant. It's not a no-knock warrant. And right now we're telling him you got to wait 30 seconds unless the officer decides there's exigent circumstances. So we're again putting the discretion as to whether or not you could kick the door in less than 30 seconds in the officer's hands. And I'm just suggesting, I think we talked about this in subcommittee, and I don't know if it was Dylan or Alex who said that the Supreme Court, and Mr. Chairman, that the Supreme Court has already defined what exigency is. And I think that we ought to at least put that in writing in this bill, rather than having to have a police supervisor or state's attorney look for it. Oh, here's what you can do under exigent circumstances, or here's what you can't do.
All right. So what I will do, and what I'll do is I've made a note of that, and we will we will look at that for tomorrow and make a note of that. at this point, I wanted to just kind of try to keep moving to some extent, because if we go down in one particular area of the bill, we really will be here until 1 a.m. And it's not that this isn't important, but at the same time, I kind of want to identify bigger issues and then continue on. So I've made a note of that and made a note of the sort of the dissonance between the execution of a warrant and then the inclusion of the exigent circumstances language, which I can see your point is it's kind of counterintuitive to some extent. All right. Are there?
I'm counterintuitive?
I'm sorry? I didn't call you counterintuitive. No,
Oh, okay. Whew.
no, I did not call you counterintuitive.
I'm kidding.
Not tonight. No.
I want to see if I can make Erican smile.
All right. Let's move on. So we're going to go to page 11 here. This is originally, I think in the bill, there was effectively free tuition for people completing a 4-year degree in criminal law. The subcommittee worked pretty extensively on a scholarship. The scholarship program worked with people in Appropriations Committee. That lives on page 11, 12, and 13 of the bill. I don't know. I think that the subcommittee dealt with that pretty extensively. I don't know, does somebody or anyone have, I have to pull up my participants, any questions about that section? All right, we're going to move on. Starting on page 14 was an addition, and this is an extension to some extent of Delegate Moon's bill that deals with the liability.
Mr. Chair, I'm so sorry.
Oh, I'm sorry, Delegate Williams, yes.
No, I was late on the draw. Just really quickly on the education thing. I don't know if this was a typo or not. And I'm looking at a different version that was originally marked. This is 18-3801 subsection B. I don't know what number or page number that is. Hold on, let me pull up the new.
On page 12.
12. Is it supposed to say means public senior higher education institution in the state? I guess that was the one question I had there. And then later on down the page under 18-3802 subsection B1, it says an and. I wasn't certain if that was supposed to be an or.
So, Mr.
Questions in that section.
Vice Chair, the Vice Chair.
Thank you, Mr. Chair. So as to your first question, Delegate Williams, in terms of a public senior higher education institution, I believe that is correct. I mean, we can run that again, but we spoke with, this pretty much was drafted by Appropriations who deals with this.
Okay.
So I'm going to go with this is correct. But we
I
can.
think that's a term of art. Yeah.
Okay.
Yeah, I think that however they refer to the public institutions, that they use that. And your second question was,
It's B1. It's kind of in the middle of the page there where it says attending a 4-year degree program in criminal law, criminology, or criminal justice at an eligible institution with the intent to be a police officer after graduation. And then it says, and who are currently police officers. I just wasn't certain if that was supposed to be a or.
I believe that is supposed to be an and because
Okay.
In the work group's discussions, I know that Delegate Shetty and Delegate Erican were concerned about, initially, it was drafted as prospective. So anyone who was going to study these things in a public higher institution, and they were both concerned about, well, what about folks who are already currently there studying these things, or someone who's already an officer who's studying these things? You know, what about them? We're leaving those folks out.
Mhm.
I believe that is why that is an and. But we can circle back with that.
But Delegate Williams, I I've made a note and we can get back to you on that point too.
Okay.
We can get back to you on that point. All right, seeing nothing else on the scholarship section, the liability section, which is at the top part of 14. Again, Delegate Moon had legislation that would have raised the caps on the liability that local government has from the acts or omissions committed by a law enforcement officer. In this part of the bill, it would raise the cap from $800,000 to $890,000, putting it in line with damage limits in the rest of the law, and it raises it $15,000 a year, and that's another thing that is present in the civil part of the law. Are there questions about the liability section? I keep losing my thing. Okay. All right, I'm going to keep going. Starting at the bottom of page 15 and going really for quite a while. But the essential parts, I think, are on, well, they start on page 17. This is the Maryland Public Safety Training Commission. This is the commission. This part of the bill would add civilian members. It also strikes several previous members of the commission, including the chair of the MML Police Executive Association, the president of the Maryland Law Enforcement Officers Incorporated, the president of the Police Chiefs Association of Prince George's County, a representative of the Warwick Program Advisory Committee. It also gets rid of the legislators who are on the council, and it does that because the commission, as we're going to talk about a little bit later, also takes on actions that members of the legislature can't be part of because of the separation of powers issue. So the change in the composition of the commission, it goes to the top half of 17. Does anybody have any conceptual questions or anything regarding the people who are on the commission? Delegate Anderson?
Yeah, thanks, Mr. Chairman. Just a quick question with regard to the legislative members. The caveat with them was that they're on the commission, but they couldn't vote. Does that still, I mean, if
They're not on the commission at all anymore. They're stricken.
totally restricted?
They're not on the commission anymore. They're removed from the commission.
No, what I was saying though is that they were on the commission, and part of the caveat was that you can be on the commission, but you can't vote.
Right.
And so none of the senators or delegates could vote because we knew that it would be a violation of separation of powers, but at least we could be on there and watch what was going on. But we're not going to do that anymore at all.
That came in, that was in the original bill. I think that was in the speaker's original bill. Am I correct, Mr.? Yes, she
Okay.
says yes. I caught her in a bad time. She said yes. Okay.
Okay.
All right. There's new training that the commission is going to have to put together. That starts at the bottom with line 24 of page 17. That includes training as to the proper level and use of force as set in the use of force statute, and we're going to get to that statute here in a moment. But that starts at the bottom of 17. 18, it also talks about the commission developing and administering a training program for the individuals who will be participating in the administrative charging committee under this bill, or the trial board under this bill. And we'll get to the Administrative Charging Committee and the trial board here in a moment as well. So there are some those training elements. I'm going to keep going here for a little bit, and then I'll stop again to see if people have questions. The commission, there's a couple years ago, we sort of had a running conversation that if local law enforcement violated reporting requirements for use of force, that money that they would receive from the new GO cap would be restricted. This, the legislation as passed by the subcommittee, if the commission would hold local law enforcement accountable for violations of the use of force statute and would engage with the comptroller and the governor's office of crime prevention, youth and victim services to ensure that grant funding was withheld from that agency that violated the use of force statute. I'm going to pause right here before I get to the next section. Does anybody have any questions about this? And for staff, Dylan, I think you can just leave the bill up because every time you switch back and forth, I lose my participants list and it's jarring. Stop. Yeah, good. All right, so we'll just leave this up for a little bit longer. All right. So moving on, at the bottom of page 19, the commission is responsible for developing a test and training for implicit bias. The subcommittee, I believe, and Madam Vice Chair, you'll correct me if I'm wrong, added the language subject to the availability of implicit bias test standards that are generally accepted by experts in the field of police psychology. That basically saying they can introduce it in court. If they can introduce it in court, then they could use it.
And that was, Mr. Chair,
Yes.
that was also to address some folks' concern that there is not an approved quote unquote implicit.
Peer reviewed.
Yes, thank you. Implicit test right now.
Yes. Okay. So that is set out by the commission, and the commission would have to figure out the implicit bias testing, and training. On the next page, on page 20, goes to the requirements that the commission shall certify a police officer who submits to mental health screening. That is as the bill was introduced, a mental health screening and a physical agility assessment is determined by the commission. Going to the end of 3209, the rest is in as the bill was introduced, where it says that as a condition of certification, the police officer has to submit to a mental health assessment and to a physical agility assessment to establish continuing fitness to carry out the duties of a police officer. Also removes prior marijuana use as a disqualifier for certification as a police officer. I'll pause here and see if anybody has any questions regarding this part of the bill. Delegate Juanita Fisher.
Thank you, Mr. Chair. And I want to thank the Vice Chair and the whole Public Safety Subcommittee for all the work they've done. I just wanted to make a comment for the record, Mr. Chair. I'm such a fan of us getting rid of prior use as a disqualifier. I would say, charges, or I guess potentially having marijuana for sale could also be a disqualifier, and depending if it was a small amount. I just wanted to put that out there for the good conscience of the committee, especially as this body and around the country, we look at decriminalizing marijuana. Who's to say that that individual wouldn't have gotten a valid state license to do that and to be a grower and other things. So I just wanted that for the good of the community. Thank you, Mr.
Okay. Delegate Malone.
With regards to the physical agility assessment, as law enforcement evolves, and sometimes you may have law enforcement that needs to be able to do things that don't involve, being, feet on the street. In particular, Luke, I think of Herb, who I think is in the administration in Anne Arundel County. I would think he'd have a hard time passing a physical agility test. Is there any outs? I mean, because you may end up losing some people where they provide something to the police force, let's say, cybercrime or white collar crime, and they don't need to, pass the physical test.
The Vice Chair.
Thank you, Mr. Chair. So Delegate Malone, the thought behind this was that this, to your point, would not be for those officers. It would, and not for, your managing chiefs and lieutenants or whatnot who are not out on the street. So as the MPTSC is developing this process, that those folks would be excluded, but the folks that are in your everyday on the street or patrolling and whatnot would have to submit to the physical agility annual test.
But where does it say that?
It does not.
To me, that's a problem.
So if you would like to submit a clarifying amendment, that could be helpful.
That should be a problem, though.
I've made a note of that. I'm going to go, Delegate Conway has raised his hand as well. I'm going to go to Delegate Conway, then Cox, then Ron Watson. Delegate Conway.
Thank you, Mr. Tim and committee. So, and again, in reference to this physical agility, how does the handicapped person come onto the force? I mean,
Mr. Chair, may I?
The Vice Chair.
Thank you, Mr. Chair. Again, I think it is would correlate to what your duties and responsibilities on the force were. So the thought behind it was, right, we are undergoing significant police reform because we don't want officers automatically, going for their gun. And so the thought was, if an officer who is out on the street is unfit and, they're chasing somebody and they can't necessarily chase them or control them in a manner or restrain them in a manner with which they're supposed to, then they would just automatically reach for their gun. And so to try to stop that, we're saying, okay, we have to make sure the officers that are acting in that capacity and that are out on the street and patrolling in their cars are physically fit so that they can, chase somebody and not get winded and just say whatever and just reach for their gun. So that was the thought, not that it's not for the officers that are not acting in that capacity.
thank you. Thank you very much.
Delegate Cox, then Ron Watson.
Thank you, Mr. Chair. So, Madam Vice Chair, on that note, was there some evidence or a study that indicated that officers that maybe can't run, jump, and leap as fast somehow reach for their guns more? Is that based on some kind of science, or is that just a concern that was expressed by maybe an advocacy group?
There wasn't necessarily a study, but, I think, the murders of Eric Garner, George Floyd, and others where that did happen, I guess you could call that the study.
Well, it came to mind because the video with the disgusting, horrible video of George Floyd, that officer looked pretty fit, if I wasn't mistaken, but that's just a thought. So the other question I had, Madam Vice Chair, was if you could explain to me why the change to mental health screening and whether that was supported by by all parties in this debate.
Where it says annually submit to a mental health assessment.
Yes, it says screening also, and I wasn't quite sure what standard is that versus the statute, I think, says psychological test.
I'm sorry. What line are you on? I'm just trying to.
Well, it went off my screen.
Okay, I don't see the word screening. If you see it, Chair, I just see mental health assessment and physical agility assessment.
Okay, maybe I misread that part of it, but
we took out screening actually because there was some concern that might violate the ADA. So we did take that out and say prior to hiring you can be subjected to a mental health assessment and screening. But if you are currently an officer, you cannot be subjected to mental health screening because that would violate the ADA. So we did take that out. That was initial thought of the work group, and then we took that out.
I think, Madam Vice Chair, I think the point was what Delegate Cox is referring to is at closer to the top of page 10.
Yes.
In the section 2, it does require an officer that is initially being hired to go through a mental health screening by a licensed mental health professional and the physical agility assessment. To the Vice Chair's, yeah, to the Vice Chair's point, the annual assessment would be an assessment. It can't be a screening because that would trigger trigger ADA.
Okay, thank you very much.
All right, Delegate Ron Watson, please.
Thank you, Mr. Chair. Just going back to Delegate Malone's comment. So, you know, my perspective of the thing is that if someone works in law enforcement and is not subject to physical agility, they're probably a civilian that works for law enforcement. But if you are an officer, you should by all means be required to meet all standards to maintain that classification. Just because you may not be a street cop doesn't mean you won't be called to be if something breaks out. And, you know, it's the same with the military. We got cooks, we got chefs. Everybody takes weapons call. Everybody has to be in shape. And so why would you think this should be an exception? I'd like somebody to comment on it. Or not. We can wait for the amendment to talk about it.
Well, I'll comment on it. Mine comes from a particular individual who I know works for the Anne Arundel County Police Department, and I believe he's in upper management. I don't think he does what we view as typical law enforcement work. You know, I think he does tech stuff and the like. And I know him through Scouts because his kid was in the same troop as my kid, and I think I'm smaller than Herb is, and I know I would have a challenge for passing some tests. And I think Herb is well viewed in the Anne Arundel County Police Department, and my concern is if this goes in place, he won't be employed, and Anne Arundel County is going to be losing an asset. And I'm not sure that's the only example that exists throughout the state. Because that's the other thing. You're putting this. The way I read this, it's being put in now. It's there's no grandfather clause, and what if somebody has a physical injury? You know, they got shot in the knee, but they're still a damn good desk cop. How are they going to pass the test if their knee doesn't work well anymore?
There are waivers for those types of things, Delegate Malone.
That's my point. There is
no waiver. The point I'm getting at is a condition of employment when you become an officer, that there are annual things that you're required to do.
Show me in the bill where it says that.
I'm not saying it's in the bill. I'm saying that's the way it should be.
I agree. Well, that's why I think there needs to be an amendment.
All right.
Delegate Conaway, and then we're going to move on. Never mind. All right, so we're now going to the bottom of page 20, the top of page 21. Situations where the commission may suspend or revoke certification. On the bottom of page 20, the commission may suspend or revoke for the violation of use of force. It shall if the police officer is convicted of a felony, perjury, or another misdemeanor relating to truthfulness or veracity, or was previously fired or resigned while being investigated for serious misconduct or the use of excessive force. The commission would also be required to create a database to track police officer decertifications for the improper use of force. I'll keep going here a little bit, and then we'll stop again. In the prior personnel files is what I'd call the next chunk at the bottom of page 22. In the middle of page 22. Police officer or a person who applies for a position as a police officer has to disclose to the place where they're seeking employment all prior instances of employment as a police officer at law enforcement agencies, at other ones, and authorize the law enforcement agency to obtain their personnel file from that agency. And with that, I'm going to stop here briefly again, because the next section is a little more extensive. Any questions? All right, I'm going to keep going. Bottom of page 22 starts a section related to SWAT teams and the requirements for reporting from a SWAT team. That's on pages 22, 23, 24, 25, and finishing at the top of 26, basically requiring SWAT teams to report when they are activated and when they're used. Does anyone have any questions with regard to the SWAT team reporting requirements? All right, we're going to keep going. 26, page 26. Nothing new necessarily on the bottom of page 20, except for the end of what I just talked about. But on 26, we're the beginning of the area where we start talking about body-worn cameras. Body-worn cameras, as was already introduced in the bill, each law enforcement agency would be required to have them by January 1st, 2025. In 27, on page 27, towards the top, section C, D, this is basically part of Delegate Moon's bill, a little bit different, that requires them to record and save 60 seconds of video footage prior to the officer activating the record button. What we've learned is that the cameras do that pretty much already. So they would be saving the images prior to the button being activated, and that gives a better sense of context. All right. Underneath that on page 27 is the early warning system. The commission, we're still in the section about the commission. The commission is required to establish an early intervention system to identify police officers at risk for engaging in excessive force. So that is where that lives in the bill. They have to develop guidelines to set that up. And then I'll look up. Does anybody have any questions regarding body-worn cameras or the early warning system? All right, we'll go to the bottom half of page 28, more than halfway done now. Going to the bottom of page 28, this is the use of force statute. And this is something that the subcommittee worked on very, very extensively. I think that there are still there may still be some work that is being done here that I'm aware of. I'll say that the use of force statute starts on page 29 and goes to 30. We'll just say it. The use of force section goes basically to 34. This is a fairly extensive part of the bill. Madam Vice Chair, do you want to talk a little bit about the use of force section? Because I know this is something that the subcommittee talked about quite a bit. And so I don't want to miss.
I can, yeah, thank you, Mr. Chair. Happy to talk about it, or I don't know if Delegate Deborah Davis wants to talk about it.
That's fine as well.
I also know that Delegate Deborah Davis has some amendments tomorrow that we will address related to training, related to use of force. So, we changed the definition from the speaker's bill as it was originally introduced in terms of use of force. And so now the bill talks about using force that is proportional to the, what is happening to the officer. And it talks about the totality of the circumstances that the officer can see and hear and observe from what's going on. And proportional being something that's not excessive in relation to a direct and legitimate law enforcement objective. So that, I think, is the biggest change that the work group took as an amendment in subcommittee in terms of changing the standard. So an officer may not use force against a person unless the force is necessary and proportional to prevent an imminent threat or to essentially effectuate an arrest of a person, and they have probable cause to believe that person has committed a crime. That's the main change that the subcommittee accepted.
Okay. Delegate Davis, is there anything you'd like to add regarding this section? You have to unmute yourself, Delegate Davis.
Yes. There was a amendment proposed to change serious injury to serious physical injury. It looks like it's been done. And I think I have an issue with it.
I'm sorry, you said you believe that there is an amendment that's in your packet there that's offered for that?
Yes.
There is, Luke.
Yeah.
In the draft I last looked at, serious injury, there was serious injury, serious bodily injury. Both terms were used at various points within the bill. I think the proper term is serious.
You said
I got to look at my own amendment.
serious physical.
Serious physical injury, because it's a term of art that's already defined in the statute, and it was inconsistent throughout the bill.
Mr. Chair,
Yes, Delegate Davis.
if you could make a note that we would come back to it and make sure we're using the
Being
appropriate
consistent.
one.
Yeah,
Well,
that's
no,
fine.
my concern is that the statute is very high level as far as what is serious bodily injury. And I'm not satisfied with that.
Okay.
And the term's not serious bodily injury.
So Delegate Malone, are you saying that you believe that the appropriate term is serious physical injury?
That's the one that's defined, that's used, and that's the one that actually has a definition. Because if not, we're going to have to create a definition.
I believe in certain sections, we're going to need to create a definition.
All right. Well, I'm making a note of that. I'm making a note of that. And
That's going to push it to next week.
wow. Delegate Cox says,
These are medical terms that we need input on.
all right, Delegate Cox.
Thank you, Mr. Chair. So I had a question about the lethal force page, and the page just disappeared. So can you tell me what page that we're on again for the
We're on
lethal
page
force?
29, the definition,
There we
it
go.
says of lethal force.
Found it.
All right, includes, and I'm reading now for the group, the discharge of a firearm at a person, a strike to a person's head, neck, sternum, spine, groin, or kidneys using any hard object, a strike to a person's head against a hard fixed object, a kick, strike, or do we have the bill up? Actually, if we could put the bill back up, I don't need to read to everybody. We can just put that back up on the screen. That'd be nice. So page 29, right. So go ahead, Delegate Cox.
Well, I didn't want to go into too much depth of discussion. I know we're short on time, but what stood out to me was the discharge of a firearm doesn't appear to be the proper standard, because you could discharge a blank. That's still discharging a firearm. You could discharge rubber bullets. You could discharge paintballs. So that would just be a thought that maybe that should be cleaned up.
Oh, Mr. Chair.
Vice Chair,
Thank you, Mr. Chair. So I would argue, Delegate Cox, that whether or not if it was a discharge of a firearm with a bullet or any of those other things that you just mentioned, that is still, I would perceive that as force. I would perceive that as lethal force. So I think that the definition is sufficient.
all right.
Don't we have less
gonna
than lethal
keep-
defined?
I'm sorry.
Isn't less than lethal defined already? And doesn't it include some of those things?
There's less risk.
Lethal force is defined.
Mhm.
I think we defined less than lethal too in there, didn't we? And I think some of those things might be in there.
We define less lethal weapon.
Less lethal weapon. A weapon that is expected to create less risk of causing serious injury or death on page 28, right at the bottom.
Right, so that would include probably rubber bullets and other things that are discharged. Which page again?
28 at the bottom, lines 30 and 31.
All right, I've made a note of this. Conway with the question, then Watson, then Crutchfield. Delegate Conway.
My question is about page 29, number 9. The discharge of a less lethal kinetic impact projectile. That's like a beanbag type of thing to the chest. I mean, that's pretty, why is that in this section?
I think Delegate Moon just raised his hand. Are you seeking to address that, Delegate Moon? No, something different. All right. It's there, but let me defer to the Vice Chair.
Discharge of a less lethal kinetic impact projectile launcher at a person's head. So this is under, that is included in lethal force. You're saying it should not be?
I don't think so. I don't think so. Now,
Okay.
they normally use that. That's a beanbag pellet, like to the chest or the leg or the back or something like that, just to knock you down. It's a knockdown.
If I'm
Okay, we have to make a note of that because I don't know.
Thank you. Thank you.
And I'd like to join Delegate Conway on that concern. I think that type of projectile is used to try to control unrest situations and for it to be less dangerous to those who may be instigating the unrest. So I think that is problematic.
All right, we're going to keep moving here because there are a number of members of the committee with their hands raised. I'm going to go to Delegate Ron Watson first.
Yeah, quick question, Mr. Chair. I mean, I see a lot of in here definitions in deadly force and less lethal, serious injury. But the thing that happens more often than that is a police officer roughs somebody up. So say I get a tooth knocked out. Where does that fall into this bill? I mean, it's not lethal. It's not less than lethal because it's not a device. But where is it? Somebody body slams me or just knocks a tooth out. How is that captured?
I think, Mr. Chair, if I may.
Please.
I think that situation would just fall into a fact pattern that a jury would have to determine when they're taking a look at the proportionality of the force that was used and whether or not it was appropriate. So it's not lethal. This bill says certain things are de facto lethal,
Right.
but So the situation you're defining, a jury would have to say, was that response proportional to the threat perceived by the officer?
Got it. Okay.
All right, Delegate Crutchfield.
Yes, quick question. Vice Chair, I guess maybe this is really to you. Going to page 30 is where we talk about in C1, we talk about the police officer signing an affirmative written sanctity of life pledge. And I noticed that the policy, though, that the law enforcement agencies must have, because usually you want to have some teeth when you're asking people to sign and affirm something. And I think that sanctity of life pledge probably should be expanded upon just a little bit to maybe sanctity of life, decency, some other elements like respect. But I do believe there really has to be a policy. I think each police agency must have a policy that's the underlying basis for the reason why this person is actually signing this affirmation. So just think about that, but I do have an amendment to that as well.
So I do know that MPTSC, and this was actually taken from something that they already have. They do have something described. That doesn't mean every department has it, but one of their best practices that they recommend is that each department have their officers sign this sanctity of life pledge, and it's more prescriptive than what is here in statute because it is in the form of a policy.
Right, understood. And all I'm saying is take that a bit further to just make sure there's a policy that's underlying this. Again, when you ask people to sign things, you always want to have some kind of policy with some teeth in it, so that if you have to come back for some reason, and maybe even an officer violates this is a means to actually go forward under the other ability to charge officers. You can charge them maybe with this as well. So just
okay.
Like I said.
Madam Vice Chair.
Mm-hmm.
If I
Delegate Davis, please. Go ahead.
this may be best added to the training section.
Yes, so we're going to take a look tomorrow. Thank you, Delegate Deborah Davis, has amendments related to training for the use of force. So good.
So we can maybe able to look at that in that context.
Yes.
Delegate Moon, then Delegate Lopez, then we're going to move on.
Thank you, Mr. Chair. I just wanted to quickly, I got my memory refreshed on this question about serious physical injury versus serious injury. And going back on it, my recollection is, and you can see some of the citations in the bill, this was supposed to refer to 3201 of the criminal law article, where there's an existing definition of serious physical injury in the law. And it looks like what happened is somewhere in the code, in our bill draft, the term serious injury slipped in instead of serious physical injury and started to replace various sections. And so that term serious injury needs to not exist in the bill, and it should always just be serious physical injury.
But if I may?
Yeah.
Delegate Davis.
I disagree. If you look at serious physical injury, you have to maim someone. Pretty much. I don't think that's the standard we're looking for.
From 3201, serious physical injury means a
Creates
physical injury.
Creates substantial risk of death, causes permanent or protracted serious disfigurement, loss of function or bodily member or organ, and impairment of the function of a bodily member or organ. You have to maim someone to create serious physical injury.
Yeah, this was as with respect to a force restriction, right?
Yes. So my response to you is we don't want to replace serious injury with serious physical injury per the statute throughout the document.
The problem is I don't think we have a definition, and I wasn't trying to be flippant when I say it's going to run it to next week. I worked in law school for a medical malpractice firm. That could be a week-long project. And I'm not trying to be flippant.
Right. I've got that written down as a note. I'm going to take Delegate Lopez's question now.
Sure, the conversation has progressed a little bit, but just to circle back, I just very respectfully want to disagree with Delegates Malone and Conway about the kinetic impact projectiles. I think anything fired at your head, your neck, your chest is pretty serious, and we're not even discussing the range at which the firearm is discharged. I mean, if you're shot point blank with anything, it can pose serious bodily, physical, however kind of injury you want to call it. So I think that should be left in there.
The problem with it is shooting those projectiles is kind of like shooting Nerf darts. I don't know how you know where they're trying to go when you're shooting them at a crowd. I mean,
Vice Chair.
Thank you. I have 3 little kids. They love Nerf guns. When I shoot them, we teach them very, very well. Even though these Nerf guns, you might hurt someone. It's the whole new neighborhood thing since coronavirus. And I'm like, you might put somebody's eye out. You might do this, you might do that. And so they are taught that, yes, you can hurt someone. You do know where they go. And so I was doing a quick little Google search here related to kinetic. I'm on a medical website. Kinetic impact projectiles, often called rubber or plastic bullets, are used commonly in crowd control settings. We find that these projectiles have caused significant morbidity and mortality during the past 27 years for penetrative injuries on the head, neck, and torso trauma. So I'm going to have to co-sign what Delegate Leslie Lopez has said.
All right.
Can I get in on this? Can I get in on this?
Delegate Conway, and then we are going to move to the next section. We're going to move out of use of force and we're going to move to the next section of the bill.
Thank you. I would like to just respond to the Vice Chair. I've heard of instances where little kids have been hit in the chest with baseballs, playing baseball, and they've died. So accidents happen, trauma does happen, but generally what we're doing, if you take all of these things away from the law enforcement, how are they going to control the crowd? I mean, they might not be intentionally trying to shoot somebody in the chest. They hit them in the chest. They don't know they have a fibrillating heart and have a heart attack. But I thank you for your comment.
All right, we're going to move on now to the bottom of page 34. 34 is the beginning of the Employee Assistance Program portion of the bill. This is House Bill 88. The Criminal Law Subcommittee actually passed this legislation, but it's inserted here in the bill on pages 34 and 35. Then we have a part that is deleted and we move right along. And the next part is the section on police accountability and discipline, which starts in the middle of page 40.
Mr. Chair,
Yes, Delegate Williams.
before we move off of the Employee Assistant Program, I did have a question. I was looking at subsection C, there where we're talking about what the Employee Assistance Program covers. My question I have for the subcommittee, I know they were in the weeds in this. I had in my notes about drug and alcohol dependency, and I didn't see that there as a mental health service to be provided. And I guess I was just wondering if there was any rationale with regards to why that wasn't included as well.
You can't be a police officer if you have those issues. That's a disqualifying, and you'd be disqualified.
Drug and alcohol, or let's just take the drug part out, alcohol dependency.
If you're an alcoholic, yeah, I'd say the Maryland Police Training Commission probably already has a rule about that.
Delegate Williams, I think that you're raising, I think also though, another point that if a drug or alcohol addiction perhaps developed during the time that they were a police officer, I think is perhaps what she's saying.
That's what I was getting at, not in terms
I'm
of.
making a note. I made a note.
Yeah, not in terms of applying, but they've been on the force for 10, 15 years, all of a sudden, you know, because we've heard about officers suffering from PTSD, things like that. And those things can manifest themselves in a lot of different ways. One of those ways, unfortunately, is through a drug or alcohol dependency. And so that's my concern.
appreciate you bringing that up, I've made a note of that as well. All right, page 40 is the beginning of the police accountability or the discipline structure. I'm going to go to the vice chair a little bit to begin to walk through. I'm going to keep doing it the way I was doing it, I guess, and just kind of go broadly through the sections. The first section is the definitions, and 3102 is the independent investigative agency. It's a 3102 that says that a shooting involving a police officer or another incident involving the use of physical force by a police officer causing death or serious physical injury shall be investigated by the independent investigative agency. And there are further details about the independent investigative agency in section 3-102. I'm going to kind of move through the sections relatively quickly, and then we'll take this as a chunk at the end. 3103, every county will have a police accountability board. The police accountability board, and so that lives at 3103. We can go into greater detail here in a moment, because if I start reading, everybody gets bored and nobody likes that. And so that's at the bottom at 41, and then 3104 at the bottom of 42. It talks about an individual may file a complaint of police misconduct with the law enforcement agency that employs the police officer. And it provides the details as to what information needs to be provided. In 3105, we have the establishment of the Administrative Charging Committee that is made up of the chair of the Police Accountability Board from that county, a designee of the District Public Defender, subject to a couple limitations, a designee of the Office of the State's Attorney in that county, a civilian selected by the county's Police Accountability Board, and the lead attorney for the superior governmental authority of the county. There's also a statewide committee. We set up a statewide charging committee to address issues related to the Maryland State Police, the Transportation Authority, and other statewide police agencies. As I mentioned at the beginning of the evening, the members of the Administrative Charging Committee will receive training from the MPTSC. There's more detail about the Administrative Charging Committee. In 3106, the vice chair can speak in greater detail about the uniform disciplinary matrix for use by each law enforcement agency in the state. 3107 is the trial board process. If the officer does not agree with the punishment that is given related to the misconduct, and there are the proceedings of the trial board live there at 3107. 3108 are the conditions by which a chief can impose an emergency suspension with or without pay if the chief determines that a suspension is in the best interest of the public. That's where the rules related to that live at 3108. 3109, I'm now on page 47, moving right along. The police departments would designate a victim rights advocate. You have these in the state's attorney's office. This would be similar for those people who were victims of police misconduct, who could serve as conduit of information to those victims of police misconduct. 3110 says that a police officer does have a right to representation, and 3111 is, I think, the whistleblower statute. And then there is an allowance for political activity by police officers and for secondary employment. This is sort of the guts of the bill. That is the big, or well, I shouldn't say that. This is another big part of the bill. And so I've gone quickly through it. I know that there are probably questions about a lot of it. I see Delegate Juanica Fisher first, and then we'll go to Delegate Williams. Delegate Juanica Fisher.
Thank you, Mr. Chair. That was a lot. I do have two questions, and maybe obviously they're for the Vice Chair. I was just, for the Independent Investigation Agency, I was a little confused on where that was housed. And then like, if someone had an issue with that Independent Investigation Agency, where they would go, if you don't mind clarifying that for me.
So the bill does not say where it's housed.
Okay.
So if they have an issue with the agency, meaning if they wanted to file a complaint with the agency?
Yeah, or maybe they made, like, if someone felt the investigation wasn't good, or they, or how does anyone, I'm just confused on that part. Maybe, yeah, I'm just a little confused on that part.
Well, I think if they think the investigation isn't good, then there's a process for that.
Okay.
But we did not say in this bill where the Independent Investigative Agency will be housed. We didn't say that in this bill.
Okay, so that's TBD.
Correct.
Okay, and then Madam Vice Chair, and maybe Mr. Chair, with the under 3-105 with the county's makeup of the committees, I guess it's a funny note, but not it has what the qualifications like for like the public defender. They can't be employed. They can't have a current case or a pending matter. It definitely regulates you to like more vintage members of the bar who may be older. I don't know how to say this the right way, Madam Vice Chair, in the sense of, anyone. Seasoned? Yeah, because it's like, anyone who's either a former public defender person or appointee from them, or anyone from the state's attorney who's a former but not doing anything is going to be like kind of older to fit those things. So I just wanted to highlight that. I'm not, I understand you're kind of doing that to not have any conflicts going on, so that it makes sense to me. I definitely do think though the pool that you're going to be able to pick from with those qualifying pieces is small, but I also understand how frustrating it is. I don't have like the best solution to offer. I'll try to think about it a little bit more tonight. I wanted to point that out. It'd be much older members of the bar.
Delegate Williams.
Yes. So I guess I digested and read through all of this last night. And so I think I have a really good understanding of how this kind of all interplays with one another. One of the things that I heard kind of continuously as we've been talking about this for months and months, when the work group was first formed and even now and moving forward, just for the community in general, is just really trying to empower the community to be involved in the process a bit more. And so along those lines, giving, I guess, kind of with the Police Accountability Board, the ability to kind of recommend disciplinary, recommend various disciplinary recommendations to the chief, if I'm understanding the way that this works correctly. And so I don't necessarily see that directly. I'm going to be submitting an amendment just to kind of maybe address that, because that's the feedback that I'm hearing from my constituents, is that they do want the citizens to be the ones who are involved. I think there's a little bit of, and whether rightfully or not rightfully so, kind of mistrust in some of the actors that have traditionally have been involved in dealing with these disciplinary procedures. And so I'll be putting forth an amendment to try to give a little bit more towards the citizenry. I understand the reason for, I guess, some of the composition that Delegate Fisher was mentioning earlier. I think there's a role to have some seasoned folks involved in the process, but also want to make sure that the community is involved as well.
Mr. Chair?
Vice Chair.
Thank you. So I would say that this bill does present a lot of citizen participation. And I would strongly argue that divesting any the chiefs and with final authority would be incredibly problematic, particularly with everything that's coming out in the news. You got state troopers. We had 20 African-American troopers who are complaining that they, had unfair discipline and weren't able to move up in the ranks. We certainly saw that in Prince George's and the ACLU report. So I would be suspect in doing, quite frankly, what the Senate did in divesting all authority in the chiefs. The way that this is set out and the way that the subcommittee saw fit was that when the investigation is complete, the investigative findings are given to the administrative charging committee, which the makeup is in here, but that includes the chair of the Police Accountability Board. So there's citizen participation there. And I should also take a step back and say that a person can file a complaint not only with the police department, but also with the Police Accountability Board, which is all citizens. And then if an officer chooses not to take whatever disciplinary recommendation that the charging committee recommends, that the trial board is essentially, this legislation says the trial board is 3 people, 2 of whom are citizens. And so that's where you get your citizen participation. So I think this legislation has a lot of citizen participation in it. And so, and the Public Safety Committee went with what's in this legislation. So.
Thank you, Madam Vice Chair. And I when I say, and one of the things I was saying was making recommendations to the chief, not ultimately being the ultimate decider. I don't think I'm in disagreement with the chief being that person, but just being able to make recommendations regarding discipline to the chief. And then if the chief rejects the recommendation, required to explain their reasoning and writing about why they are rejecting the recommendation. So that's what I will probably be putting forth. And once I have that back from the amendment.
Madam Vice Chair, would you remind me, please? I think the other issues that the work group and that the subcommittee heard pretty extensively was about the wanting to make sure that there was sort of a consistency to discipline across the state, if I'm not mistaken. And can you talk a little bit more about the disciplinary matrix that's in the bill? Because I don't want to be dismissive of the issues that Delegate Williams is raising. I kind of want to shine a light on that because I think that does go to some of those issues. And I will shut up. Vice Chair.
Yes, Mr. Chair. So this legislation recommends that there be a uniform disciplinary matrix that has to be used by all of the departments, because right now some departments are not using a disciplinary matrix. It's kind of complete discretion of the chief. And so I think that everyone should have an expectation and everyone should be on the same page. And that's what the work group thought across the state. And so that would be the floor. So whatever the discipline was that was recommended, then the chief couldn't go below that. They certainly could go above that. But so all the departments will be on the same page in terms of what discipline was being offered for whatever the infraction was. And I think that provides consistency, and the work group thought that that provides consistency across the state where there is no uniformity right now because some departments aren't even using a matrix.
All right, Delegate Ron Watson with a question.
Yeah, sorry, Mr. Chair. You guys are moving.
Don't be sorry.
Trying
No,
to
that's why we're here.
So question, so the police accountability boards are applicable to the municipalities, is that correct?
I think the police, go ahead, Vice Chair.
Each county and the city will have one. So the municipalities would or could enter into an MOU with Prince George's County to use the county board.
That's at the bottom of page 41, 3103A.
So in the case of my city, Bowie, if we already have one, do we have the flexibility to have our own chairperson who resides in our municipality versus somebody on the outside?
So say that again, you already have a police accountability board.
Yeah, so it's a question of how the chairperson is selected, right? We wouldn't want somebody outside to come into our municipality and run that. We'd rather run it ourselves. Is there anything that precludes that?
So I think that's a good point, and we should note that
Okay.
and see. That's a good point.
If you recall, since we've been talking police accountability, I've always asked, how does it flow down to the municipalities if we have Greenbelt Police and Seat Pleasant and Suitland and all these types of things? Well, Bowie has tried to, pick up the pace, and I don't want to do anything that thwarts what they already have in place.
Okay, thank you, Delegate Watson.
Delegate Cox.
Thank you, Mr. Chair. Thank you. Madam Vice Chair, I was curious about the section where it said the superior governmental body, the chief attorney for the superior governmental body. What is that, a uniform term of art across all the counties and jurisdictions of Maryland?
Superior governmental authority is like the county attorney in your county, the county attorney's office.
Who would define that, though? It would be the county that would decide who the superior one is?
I believe that's a term of art, and I'll try and find. Well, we can make a note of that and get the specifics, but I believe that's a term.
It's defined back in 3101.
Okay, good.
The governing body that oversees a law enforcement agency.
I know sometimes there are separate attorneys in the county that may have governmental authority in a different capacity. So I just was curious, but that's good. Then the other thing I wanted to just check on was, Madam Vice Chair, I heard you say that that citizens would be on the board. And I couldn't find where that was. I see a civilian or a resident of a county, but it looks to me like that would include residents, even in, not necessarily citizens. Is that?
Are you talking about the Police Accountability Board?
Both that and the charging committee.
Okay, so the charging committee is made up of the chair of the Police Accountability Board, which is, they appoint civilian members to the charging committee. I'm looking for the makeup of it.
Delegate Cox, your issue is between the distinction between a resident and a citizen?
Correct.
So it's a resident of the county and the jurisdiction. It's a resident.
Okay.
That's on page 43 and 3105 A2 Roman 2 1.
A resident of the county, right? Sorry, I just said citizen, thinking.
We're fine. No, it's resident, not citizen.
Yep.
Okay. Thank you.
All right. I don't see any further questions related to this, the last part of the bill. Again, a significant part of the bill. As I think the committee can see, the subcommittee and the work group worked really extensively on this piece of legislation. There are still issues. There may be a couple issues that we have to address, and I know that Delegate Davis has an amendment, again, as was mentioned, related to training and the use of force statute. So we'll be looking for that. My intention is to begin taking up some of these amendments tomorrow at 2 o'clock. We have a floor session tomorrow at 10. I'd like to see subcommittee chairs at 12:30. At 2 o'clock, again, we'll have a vote session where we'll begin to take up amendments on the bill. All right, ladies and gentlemen, I see Delegate Juanita Fisher has a question. So we'll do that, and then I think we will stop.
Yes, Mr. Chair, I just wanted to clarify that I had 2 amendments that I submitted that they were received for tomorrow.
No, I understand. That's fine. I think we've got them. We can take those up tomorrow. Okay. So I want to thank everyone for their questions and for their insights. I do again want to thank the Vice Chair for everything that she has done and continues to do on the bill. And we will talk with everyone, talk with everybody tomorrow. So thank you all very, very much.
Good job, Vice Chair.
Good night. Okay.